Mic check, mic check. Do we have a bad mic like we did last night? Let me know in chat. Well, other than it being my voice, the mic sounds pretty good.
Welcome to the Dire Wolf Show, where we believe that America is exceptional and that our constitutional rights should never be infringed. I am Dire Wolf. On our show, we bring you the truth and debunk fake news. If you love laughing at the insanity of the regressive left, sit back and relax. Boy, do I have a show for you.
Right. Welcome back, Wolfpack. This is Fox Trevize here for your second Kyle Rittenhouse trial update. Second of who knows how many. We'll see how many of these I can do before I literally just die because of how much streaming this is. I approximately watched 15 hours worth of content today. At 2x on YouTube between Rittenhouse and yesterday and today and other content I like to watch and all just non-stop direct injection into my brain. And then I cap it all off with 1 hour, 2, 3, 4, 5 hours of streaming tonight. So I hope you'll all enjoy it. All right, so yesterday, I'm just going to jump right into this. So yesterday, we had an update on the Kyle Rittenhouse case. For those of you who are not aware, I'm not going to do a ton of background on it because there's some assumed knowledge that you have coming into this, especially this being the second of a series. But just the quickest recap is last year during the riots in Kenosha, Wisconsin, Kyle Rittenhouse was involved in several self-defense shootings over the course of a 5 to 15 minute period in which he self-defensedly killed 2 people, severely disarmed another one, and shot at several other people, either on purpose or by accident. Kyle is charged with 6 counts of various things, which we talked about last night. His trial has started this week. Yesterday was day 1. Today is day 2. Yesterday we covered a little bit of last week's pre-trial where they did voir dire, which is jury selection. And then we covered yesterday the opening arguments. And I cut off where after the opening arguments from both sides, from the state prosecutors who's prosecuting Kyle with 6 counts of various things, followed by the opening arguments from Kyle's defense team. And that's where we left off at. And there was a little bit more that happened last night. That's when we starting off tonight, where we had the first several witnesses come take the stand and be examined by the state and cross-examined by the defense. So let's see here. So to start off, like I said, yesterday we left off with the end of the opening statements. And last night, this happened on day 1, so kind of a day 1 continued to get us started off here. Let's see here. So the first witness that was called to the stand, and this guy is going to be real important, and I got a lot of content on him. We're going to go over 2.5 rounds of testimony here. We had 3 people take the witness stand up through now. I stopped watching at about 4 o'clock p.m. Eastern, so about an hour and a half ago. The trial is still going on, so as I do these updates, they're going to kind of be half days, just because, I can't watch the stream while I'm streaming. So Dominic Black is the first person that testified. We're going to go through 2 full testimonies and then half of another one tonight before we're done here. Hoping to not take 2.5 hours like last night. Hopefully, we'll see. All right, so Dominic Black took to the stand yesterday on day one. He was the very first witness, and he was called by the state prosecutors. He's their witness, apparently. So Dominic Black, very important character in all of this. A figure that we didn't, first time hearing of him was yesterday, probably the first time you guys are hearing of him. But Dominic Black is going to be a central figure in this case, and I'm going to explain why. So Dominic Black is 20 years old. He would have been approximately 19 at the time of Kyle Rittenhouse's self-defense shooting incident, which was in August, I think 24th or 25th of 2020. So last year. So Dominic would have been about 19 at the time. Kyle was about 17 at the time. Kyle's now 18, and Dominic Black is now 20. Dominic Black came to know Kyle through dating Kyle's sister. While dating Kyle's sister, Dominic Black became very, very good friends with Kyle. And in fact, later on, they're going to, the defense will cross-examine that they were such good friends that they actually referred to each other as brothers. That's how tight of a bond that they had developed. Dominic Black had known Kyle for approximately 9 months prior to the self-defense incident. Kyle had hunted with Dominic Black and his family at least once, and they had shot guns on Dominic Black's property owned by his family multiple times. Let's see here. This is where we start getting into some hairy situations here. So there was a lot of question as to how did Kyle Rittenhouse come to acquire an AR-15 rifle? Because he was 17 at the time, and there's a few ways in which he could legally possess one, but not many. Being 17 years old, there was a lot of restrictions on how he could come about having owned an AR-15 and be holding it in his hands. And there's been a lot of questions about that the last year of this, and one of the charges against Kyle is that he was in illegal possession of this firearm. So how did Kyle get the AR-15? Well, Dominic Black testified under questioning from the state prosecutors. Dominic Black testified that he essentially did a straw purchase for Kyle, saying that he had come to an agreement with Kyle that Dominic would buy the AR-15 with Kyle's money. Dominic would buy it in his name and presumably fill out the FBI background check in Dominic's name, even though he was purchasing it on Kyle's behalf, which is that's illegal. But the deal that Dominic came to Kyle with, is what Dominic testified to, was that Dominic would keep the AR-15 until Kyle was 18, and that Kyle was only to use it when they were together. So it was kind of, shall not be infringed, right? Second Amendment. The right to keep and bear arms shall not be infringed. So there is no age limit on that law, right? I am of the opinion that the Constitution supersedes all. And so any law or regulation or government form that infringes on your right to keep and bear arms is not valid, even if it is legal, right? There's kind of a distinction there. So I think that within the boundaries of the Constitution and what I'm sure goes on a lot, this isn't Kyle being unsafe with a weapon, right? This is just the government has an onerous regulation, and Kyle's getting around it a little bit in a way that's illegal. Maybe not morally wrong, but it's illegal. And Dominic is helping him circumvent that law, but in what would be a, let's call it, for lack of a better term, responsible way. Saying, I'm going to help you circumvent this law, but I'm going to hang on to the rifle until you're 18 because responsibility and all that stuff. Again, I think that there is two ways to look at this. You've got kind of the what is morally and constitutionally correct on one side, and then what is strict to the letter of the law on the other side. Just because something is a letter of the law doesn't necessarily mean that it's correct. It doesn't necessarily mean that it comports with the Constitution. So, there's a couple ways to look at that. But that doesn't change the fact that Kyle will go to jail or not go to jail on the letter of this law, And the jury is going to have to make that decision. Now, they could do jury nullification and just say, we don't care. We don't care that was the law. Kyle's innocent. That could happen. I certainly hope that does. But as of right now, it does appear that Kyle and Dominic are like very, very afoul of this law of straw purchases. Let's see here. So Dominic admitted to buying the AR-15 in Dominic's name using Kyle's money. The defense showed Exhibit 27 and Exhibit 28, both of which were AR-15s. Exhibit 27 was a disassembled AR-15 that had the lower disconnected from the upper, and Exhibit 28 was an AR that was fully assembled. Both weapons were declared to be unloaded, and it was determined that showing them to, they didn't actually hand it to him, but showing it to Dominic, he identified the disassembled AR-15 as Dominic's personal AR-15, and the assembled AR-15 as the one that was legally registered to Dominic, but was the one that he had straw purchased for Kyle. I think it's absolutely incredible that Dominic's AR-15... Now, I understand why Kyle's AR-15 is in evidence, right? But Dominic's AR-15 is also in evidence. But somehow Anthony Hubert's skateboard that he tried to kill Kyle with... let's not mince words about that. Anthony Hubert tried to murder Kyle Rittenhouse with his skateboard, and we talked about this yesterday. Somehow that skateboard didn't find its way into evidence. Somehow they were just unable to, over 14 months, to convince Anthony Hubert's old girlfriend to give up his... give up this memento that she had. I'm sure she had fond memories of him hitting her with it, because as we know, Anthony Hubert was a prolific domestic abuser. So again, somehow Dominic, who was not involved in either of these shootings, he has his AR-15 essentially impounded as evidence, yet somehow the attempted murder, the would-be murder weapon of Anthony Hubert can't be found, can't be put into evidence, can't be checked in. Yeah, I'll let you guys think about that one. So both guns were stored. So both Dominic's, is presumably Dominic had other guns, rifles and pistols, presumably, though I don't believe that was testified to, but you can kind of imagine based off the types of stories that Dominic's telling about his experience with firearms that he probably has other ones. Let's see here. So Dominic kept his AR-15 and the one that he had straw purchased for Kyle, kept both of those guns in Dominic's stepdad's safe. So we got to, hopefully you guys are following the pronoun game here, which is why I'm trying to use everybody's proper nouns every time rather than saying he, because it gets a little complicated, because you've got Kyle's sister's boyfriend's stepdad's. That's where the guns were, but it's easier just for you guys to clarify that it's Dominic, who is Kyle's very good friend, kept the AR-15 that Dominic straw purchased for Kyle. Dominic kept that AR-15 in his stepdad's gun safe that was locked. Dominic testified that he did not have unrestricted access to that gun safe. Once the gun was in there, he did not know what the code was to get them out. Only his stepdad did. Let's see here. The defense, or no, not the defense. We still have the state questioning Dominic at this point, and they brought up this picture, which you can see that this is a screenshot directly out of what they were showing the jury. You can see that there's some extra information on this picture that is not just Kyle's profile picture. So they brought up this slide and asked Dominic to identify Kyle's profile picture. Is the AR-15 in Kyle's profile picture, is that the one that you straw purchased for him? And the answer was yes. Where are they in that picture? Kyle's profile picture was taken on one of Dominic's family's properties where they could go hunting, and there was a little bit of a gravel shooting range, and they could go out there and just do whatever they wanted. And so that is where that profile picture was taken. Now, it's funny, but also very dirty and underhanded that the state chose to show the image of Kyle's profile picture in this manner. Surely they could have clicked on Dominic, or surely they could have clicked on Kyle's profile picture and extracted the full-sized, full-quality image. Or perhaps when they did the screenshot, they could have, only screenshotted the profile picture. Nope, they screenshotted the whole web page. And why did they do that? Well, I mean, just look at Kyle's screen name on TikTok. It's funny. I'm sure that before all of this happened, he was probably a bit of a shitlord. And while possibly inappropriate, his screen name did make me laugh. However, is it appropriate for the state to have shown this to the jury in such a manner that obviously is including extra information meant to bias the jury against him as a immature child, which maybe he was, maybe he wasn't, but Kyle's maturity is not, his maturity on TikTok and social media is not what's on trial here, though the state would beg to differ. Let's see here. Katano on YouTube's asking, is the defense doing an awful job, or is it just me? We'll get into this. We got a ton of stuff to get through tonight. I don't think the defense is doing a terrible job. I don't think that they're doing a terrible job. I think that they're doing fine. We'll see how it goes here. All right, so let's see here. So there was some key information that was revealed today that was unknown. Obviously, if Dominic has testified that the AR-15 is locked in his stepdad's gun safe, and Dominic and Kyle don't have access to that, how is it that Kyle came to be in possession of that rifle on the day of the incident? Let's see here. So basically because of the riots, which Dominic testified that he lived about 5 minutes from the courthouse. The courthouse yesterday and in previous days was mentioned to have been within blocks of the riots. So you might be able to extrapolate that Dominic Black's house, was probably within about 10 minutes of the riots. So I actually, a little bit of a fact check, I incorrectly said that the night that Kyle shot the people that he did, that was the second night of riots in Kenosha. That was actually the third night of riots in Kenosha. This happened on a Tuesday night. Jacob Blake was shot on a Sunday afternoon. There was riots on Sunday night. There was riots on Monday night. And then there was riots again on Tuesday night, at which Kyle was defending himself at. Let's see here. So again, Dominic's house is, within about 10 minutes, not too far away from where the main riots were taking place at. And Dominic's stepdad had taken the step on Tuesday, again, the third day of riots, had taken all of the guns out of the safe and staged them around the house in case they were needed, though I believe it was mostly just in the basement. I think it was just kind of a wording issue. I don't necessarily know if they were like hiding them in plants or something like that. But he had just had them out so that they were ready if the house needed to be defended. So the state continues to question Dominic. The timeline, which actually, let me see if I can find him here. I can't remember which person he is in the picture that's up on the screen right now. I know he's in the picture, but I can't remember which one. Let's see here. So the timeline is basically, they were questioning Dominic about the timeline. So basically, from Dominic's perspective, in the early morning, or the morning/early afternoon of Tuesday, Kyle and Dominic went downtown to where one of the car lots had been burned. Obviously, you guys have probably seen the pictures of the used car lot just completely on fire, 100 cars all being burned to the ground. And so they had driven down around there to kind of check out what was going on. They saw people trying to clean graffiti off of their old high school and spontaneously decided to stop and help clean the graffiti for about 2.5 hours. Again, what did I say yesterday? The government abandoned these people to lawlessness. The government of Kenosha, Wisconsin, the state, the county, whoever, even the U.S. government at a certain point abandoned these people to lawlessness during the riots. That's why you've got all of these businesses being burned to absolute rubble. All, hundreds of thousands of dollars of car inventory being burned to the ground. People's livelihoods just totally destroyed. Graffiti destroying all of their city, burning down city vehicles, just general mayhem and danger. So the government just totally abandoned these people to lawlessness. And now they want to judge them by the laws that were not in effect while they were being attacked. These kids, is 19 and 17 really a kid? No. Am I being a little, am I trying to create a mental image for you that these were young people who shouldn't have had to be taking on this much responsibility? Yes. So these young men decided to spend the day cleaning graffiti. They could have been doing anything else. They could have just gone upstate to one of Dominic's big properties and just headed up there and just camped out and shot guns. They've done that before, but they decided, this is our town, we're going to take some responsibility for it, because certainly no one else is, and we're going to go downtown and spend the day spontaneously cleaning graffiti, because that's what 17 and 19-year-olds want to do with their time, is they want to go spend 2 hours on a Tuesday afternoon in the middle of the summer scrubbing Black Lives Matter graffiti off of a high school. Yeah, these guys were just absolute terrorists, weren't they? So they spent all their day cleaning graffiti off the school that was left by Antifa and BLM, organizations that are both endorsed by the Democrats. There was not some government program to come and clean this up. It was them, members of their community, trying to clean up the aftermath of being abandoned by the government to the anarchy of militant leftists. So the government just abandoned the city, left the citizens to clean up, and first they left the citizens to survive. Your current mission is to survive. That's what the government did for them each night during the riots. And then the next morning, there's no government program coming in to clean up the mess. No, the citizens have to deal with that. Again, 17 and 19-year-old men could have been doing anything else, decided to go down and spend their time scrubbing their old high school. Let's see. You guys want to see what the character and motivation of Kyle and Dominic and some of the people they were with that night? Well, I point you no further to them spending their afternoon cleaning up graffiti that was left by the militant wing of the Democrat Party. After they spent a few hours trying to clean graffiti, they went back to Dominic Black's house. And then this is where. So I was writing these notes as I'm watching the stream, right? So what I wrote here is going to get corrected later because there were some Dominic's testimony was a little bit confused on the timeline of events, and so there'll be and I'm going to try and correct it here, but he had misspoke about the sequence of events. He had said that they had gone back to his house, then they had gone out to buy gunslings, which as you can see in the picture here, Kyle has a sling that attaches his AR-15 to his body. Dominic also had one of those. They had purchased those that day, Tuesday afternoon. And so Dominic said after they did graffiti cleanup, they went back to Dominic's house, then they went to go get gunslings, then they went back to Dominic's house, and then they ultimately would go out to this picture that you're seeing on the screen right now, and meet up with some other people trying to defend CarSource. The correct sequence of events was that they had only gone back to Dominic's house once. That is when Kyle grabbed the AR-15, which we'll talk about that in a second here. They had then driven to a gun store to get slings, and then they drove into the city to take this picture here. Let's see here. So the sling that they bought, regardless of when they bought it in the timeline, the sling that they decided to buy on Tuesday afternoon, that choice that choice definitely saved Kyle's life within a few hours from that. As we saw in the videos of that night, several times the sling on Kyle's chest had been pulled taut as people tried to get the AR-15 away from them. Much to their chagrin, they got about 115 grains of it instead of the full rifle. So I think it's rather obvious that Kyle would more than likely be dead had he not had that sling, because somebody would have gotten that rifle away from him. He would have dropped it, and then they would have shot him with it. So that decision, for better or worse, wherever it happened at in the timeline, that was probably something that saved Kyle's life later on in the night. Let's see here. So again, this is the part where I said I was correcting myself because Dominic misspoke in his testimony. Dominic said that they went back to Dominic's house after they purchased the slings, but that's it. He flipped the order. So read this as this is the first time that they're going back to Dominic's house. This is after they've cleaned up the graffiti, they head back to Dominic's house, where Kyle ended up grabbing the AR-15 out of Dominic's basement, where his dad had left/staged all of the weapons that were in his gun safe. Later that day, they would go out to the car lot. Dominic describes how, shortly before and after the picture that you're seeing on screen here, the people around them and the owners of CarSource were discussing tactics, where they would stand, whether or not they could get access to the roof, what they should do if specific XYZ events happen. The way Dominic was describing it, it really sounded like they were preparing for something like a zombie apocalypse. And why? Why were they doing something that seemed like they were setting up for a zombie apocalypse? Why did 19 and 17-year-old civilians need to be talking urban warfare tactics? Well, it's because the state that is prosecuting Kyle Rittenhouse for defending himself also abandoned Kyle's city to anarchy and leftist violence endorsed by the Democrat Party that night. The only reason Kyle was in a position to have to defend himself is because the state and the city abandoned the civilians to anarchy. And then now they want to judge. There was no laws that night in the city. And then now they want to judge Kyle by the laws they suddenly have the day after. I said it last night, and I'm going to keep saying it again tonight. Kyle should be judged by the laws that were in effect in Kenosha the night of the shooting. There were no laws in effect that night. The police had stood down. They had set up a barrier. You can't go past this line, but anybody inside the police circle, you can do whatever the hell you want to each other, and Kyle should be judged by that standard. Not by the standard of the laws that were reestablished the next day, but he should be judged by the standard of the lawlessness that the police, the government, the state, the National Guard all allowed to happen that night. Let's see here. I think it's just absolutely nuts. You've got basically, again, the way Dominic's describing it, it really seemed like they were preparing for a war zone. And again, this is night 3. They aren't guessing. This isn't them speculating or fantasizing or being like preppers about it. No, they are talking about what they saw happen the last 2 nights. They're planning to respond to exactly what they had seen already, what they'd already experienced. So this isn't them fantasizing or pretending that they're in the military or something like that. No, this is them. They have no choice. This is a zombie apocalypse. There is no other choice but to engage in defense against what is an urban warfare environment. And then you've got, and why are they there? Well, because the state abandoned them. The state could have sent in the National Guard. The city could have even just sent in the regular police, but no, they all pulled back and just let happen whatever was going to happen. They allowed this to happen. And then after abandoning Kyle and all of these people, after the state abandoned them, and I'm using the word state as kind of a stand-in for government, after the government abandoned these civilians to anarchy, now the next morning, the state is backseat quarterbacking the whole situation that the state ultimately allowed to happen. There's a lot of questions in this case about, well, Kyle's from the next city over. What was he doing in Kenosha that night? If he hadn't been in Kenosha, he wouldn't have, shot these people. And so that's proof that he's guilty. Well, you want to start playing the dependency game there, where you're doing the causality chain of whose fault is it really. Well, I mean, you could easily just jump that back to it's the city's fault because they didn't enforce the laws that night. It's the county's fault. They didn't force the city to enforce the laws that night. They didn't send in, but there were certainly sheriffs around there. Again, there was police lines and barricades defending police areas, making sure that the riot didn't go out further than what it was. But within the zone that the police cordoned off, it was bedlam. And that's what's being testified to by multiple people that night. So, and again, you go back even further. Okay, well, the state, the governor, they could have sent in the National Guard. The national government could have federalized the National Guard and declared it an emergency and sent them in. You want to play the blame game of why was Kyle there that night? Well, there's a whole bunch of government before that. There's a whole bunch of government that's responsible for that. Now, maybe that's a little bit contrary to what I normally preach on this show, is because I'm a conservative, small government, more libertarian anyways, taxation's theft and all that stuff. So why am I putting all this burden on the state? Well, because the state is the one that has the monopoly on it. As you can see in this situation, the state has declared itself a monopoly on violence. And then when they abandon Kyle to violence and Kyle has to defend himself, all of a sudden the state says, well, you can't defend yourself because we've got the monopoly on violence and we've got the monopoly on defending you. Yes, the state has the monopoly on defending you, but they're not exercising that power. They've just abandoned you. All right, so the timeline continues. Let's see here. Oh, okay. So the state asked Dominic, why did Dominic, not necessarily why was Rittenhouse having a gun, but they asked Dominic, why did Dominic himself feel the need to have a gun? And again, I think this wasn't Dominic's answer. Dominic said, he was concerned for his safety and wanted to make sure that he could defend himself if he needed to. But again, ultimately, the reason why Dominic needed a gun is because the state failed to keep law and order. The same state that's prosecuting them. The timeline continues. The state continues quizzing Dominic on the timeline from that day. Dominic testifies that at some point after they got to Car Source, sometime after this picture was taken, they split up. Kyle goes to the gas station, which was infamously in multiple videos. I'm sure you guys know which one I'm talking about. It was called Ultimate Gas. All these fun names, Car Source and Ultimate Gas. It's kind of just very descriptive names. Let's see here. So Kyle tries to, at some point after, again, this is really, really blazing through the timeline here. Kyle went down to the gas station. I'm sure you guys have seen the videos of him down there. At some point, which we'll get back into, he put out a fire that was in a dumpster. And Kyle starts making his way back many minutes, tens of minutes later, back towards this original car lot where you're seeing the picture at. That's where most of the people were staged at. And so Kyle's going back there to meet up with the main group, kind of a safe area. This is when Kyle is blocked by a police line. This is a police line and an incident, an interaction that Kyle had with the police that we talked about yesterday. The state prosecutor in his opening statement yesterday actually suggested that Kyle not circumventing the police line is evidence that he was looking to hunt and kill somebody that night. So basically the state is, their argument is that if Kyle really didn't want to hunt and murder somebody that night, he would have disobeyed a direct police order. That's essentially what their opening statement was. So Kyle didn't do that. Kyle obeyed the police orders. They sent him back towards the gas station where Kyle would inevitably run into the events of that night that would kick off the first shooting with Rosenbaum and all the stuff that would follow. See here, Dominic was the person that Kyle Rittenhouse called on the phone after he shot Rosenbaum. You guys may have seen over the last year that after the first shooting when Kyle shot Rosenbaum, and Kyle is retreating from the scene, Kyle's on the phone, and you can actually hear in some of the live stream videos, you can hear Kyle on the phone with something that looks like a phone up to his ear. Kyle saying, "I shot somebody, I shot somebody." Dominic Black, the person who's testifying right now, he was the person on the other end of that line. after the call, Kyle would go. I think this is all testimony from Dominic that I'm reciting here. After the call, Kyle would go on to shoot Anthony Hubert, Gage something. He would shoot at Dropkick Guy, all in self-defense, before ultimately meeting back up with Dom after the shooting events occurred. Dominic says that when Kyle made it back to Car Source after having been involved in those incidents, he testified, and it was also shown that Dominic, the night of the event, had said in a police statement that Kyle was sweating like a pig. He was extremely pale. He was nervous, possibly appeared to be in shock. He was frantic. Kyle kept saying, I had to do it. I had to do it. That's what Dominic testified. It seems to me that Dominic was describing shock based off all the things that Dominic was saying, which is obviously pretty likely given the circumstances. If you've, regardless of the need or efficacy of it, any of you listening, if you are in the position to have to kill two people, severely disarm another, and shoot at several others in an incident in which it was life and death for you, you're gonna be in shock afterwards for sure. Let's see here. Let's see. So the state, let me see if I can figure out what my shorthand in these notes were. The state prosecutor is an idiot. That's what I wrote. I'm not exactly sure why I wrote that, though. It's accurate. I can tell you for sure that it's accurate. Let me see if I can figure out where I was going with this. The state prosecutor is an idiot. He asked, did Kyle allege that someone was trying to shoot him? Okay, so the state prosecutor was asking Dominic, did Kyle, when he made it back, was he saying that somebody tried to shoot him? Was he saying that somebody had a knife or that they were trying to attack him with any kind of weapon? And this is a really stupid question because we can see all of those things in the video. The only thing I don't think we saw was a knife, but I wouldn't be surprised if those were somewhere in people's pants or concealed, just not visible in the video. But in the videos that are publicly available, we absolutely see Gage, the man who is disarmed, attempt to point a Glock at Kyle's head. We definitely saw Anthony Hubert swing a skateboard twice at Kyle's head. We saw Yellow Pants hit Kyle in the head with a rock, and Dropkick Guy, well, as his name implies, drop kicked Kyle. So I think the state was trying to, again, the case that the state's trying to build is that Kyle, let me back up here for a second. So the way the charges work, the self-defense shooting charges, of which there is 2 charges of homicide, Kyle's defense on those 2 charges, and tangentially a defense for the other 4 charges, 6 charges in total. Kyle's defense is privilege of self-defense. Under the privilege of self-defense, now this might be different in everybody's state, but within Wisconsin law, there is a provision for self-defense shootings in which you are covered under what is called the privilege of self-defense. The privilege of self-defense allows you to break other laws, such as murdering somebody. If you are acting under the privilege of self-defense, then the law against homicide no longer applies to you. This is not legal advice. As soon as Kyle pled not guilty due to claiming the privilege of self-defense, he is, as our system works, you are innocent until proven guilty. So Kyle, while he knows that he's guilty of homicide, everybody knows that. That's not in question here. The question is he able to claim privilege of self-defense of those homicides? And as soon as he claims privilege, it is up to the state. He's innocent until proven guilty, and so he is presumed to have the privilege of self-defense. Kyle is presumed to have defended himself and to have that privilege until the state can prove otherwise. So as soon as Kyle claimed the privilege of self-defense, the state of Wisconsin they have the burden to prove that Kyle was not acting in self-defense, which is going to be a really given the video evidence, is going to be a really, really hard thing for the state to do. But what the state was trying to do in that line of questioning with Dominic is, Dominic, did Kyle say that somebody was trying to hurt him? Did he say someone was shooting at him? Did he say somebody had a knife? Did he say somebody was attacking him? And Dominic saying no. Well, it doesn't matter that Dominic said no. It doesn't matter that Kyle didn't say those things because we've seen them in the video. And what the state's trying to do is say, well, Kyle didn't think he was being attacked, therefore he didn't have the state of mind to think he was defending himself. So he must have just been out there hunting human, trying to murder people, because he didn't have in his mind that he was being attacked. To claim self-defense, you have to, again, because the burden's on the state, the state has to prove that Kyle didn't think in his head that his life was in danger. Right now, with the presumption of innocence, the presumption is that in Kyle's head, he felt that his life was in danger, and therefore he is covered under the privilege of self-defense. The state has to prove that Kyle did not at any point in time think that his life was in danger. And part of the Wisconsin statute is you don't even have to be correct. If it's found out later on that you got spooked by something and you misinterpreted a situation, and at the moment you thought your life was in danger, but having reflected on the broader context with additional factors that you were not aware of at the time, if it turns out that your life really wasn't in danger, it doesn't matter. It matters if you thought at the time with the information that you had available to you, was your life in danger. Obviously, there's probably a lot of ways you can think of that would be abused, and possibly, but that's not what's at issue at this case right now, so I'm not really going to get into any of that. So right now, the state is trying to prove that Kyle, at the moment, because he didn't say someone was trying to shoot him when he got back to Dominic, the state is trying to allege that to the jury that, well, if Kyle really thought that his life was in danger, he probably would have said something about, oh, they were shooting at me, or oh, they were attacking me, or oh, they were chasing me when he got back to Dominic. But he didn't say any of those things, probably because he was in shell shock. But the state wants to pretend that shell shock 5 minutes after the incident, that is evidence that Kyle, in his mind, did not think his life was in danger, which is stupid. All right. Let's see here. After the shooting and after Kyle made it back to Car Source, Dominic drove Kyle back to Kyle's house, which is in Antioch, Illinois, which is, I know it's this was a big point of the case too. So Antioch, Illinois is where Kyle's home is. Kyle works in Kenosha, Wisconsin. Kenosha is approximately a 10 to 15 minute drive from Antioch. So yes, they are over the border, but the border is very incidental. These are cities that are right next to each other. You can probably see the northern tip of Antioch from the southern tip of Kenosha. I don't know that for sure, but you probably can. They're very, very close together. So Dominic, it was also determined today, this is new information, again, along with being introduced to Dominic Black, who, like I said, it's going to be a central figure here. We also found out that Dominic Black is currently facing 2 criminal charges for having illegally provided a gun to Kyle, who was underage at the time. And these criminal charges against Dominic are specifically linked to illegally providing a gun to somebody who went on to use that gun in homicide. So because Kyle killed 2 people with a gun that Dominic straw purchased for him, Dominic's on the hook for that too. So Dominic is facing 2 counts, again, 1 for each person that Kyle cured of pedophilia and beating their girlfriends. And each of those carry 6 years. So Dominic is looking at not just what Kyle's looking at. Dominic is also roped into this now, where Dominic could be looking at up to 12 years in prison for the events of that night. Let's see here. By the state prosecutor reiterated that Dominic is, by testifying in this case, Dominic's case for his 2 charges were put on hold and that Dominic, by testifying in this case, has given up his Fifth Amendment right. So obviously, given up his Fifth Amendment right to not self-incriminate, which he's very much incriminating himself by testifying in Kyle's case. One of the central aspects of Kyle's case is a gun that Dominic illegally purchased for Kyle. So by testifying anything about that, Dominic had to admit that, yes, he illegally straw purchased this firearm. And so he's now self-incriminated, and that will be used against him in his court proceedings, which we'll get into that in a second here. But Dominic could have invoked his Fifth Amendment right to not self-incriminate and just not testified and not said anything. All right, so the state rested their case for a little bit and allowed Kyle's defense attorney to cross-examine Dominic Black. They reviewed Dominic's relationship with Kyle. As I said earlier, this is where we were treated to the bromance that they call each other brother, at least they did. They had a very close relationship. Let's see here. They went through the timeline again with Dominic. And this is where we corrected on cross-examination that timeline flip-flop that I was talking about earlier, because the cross-examination by the defense attorney said, wait a second, I thought this was the order of events. And Dominic said, yep, that was the order of events. And the defense attorney said, well, you just testified that it was the other way. And so they got that kind of straightened out, I think. I'm not really sure how big of a deal it is that there was a flip-flop in the timeline there. I think that's not as... I don't think it's a big deal. It was just something I noticed. There was this hilarious description by the defense attorney to the court of how red dots work. There was an allegation at some point that somebody, possibly Kyle, was shining a laser sight at people threateningly. This would turn out to not be true. But Kyle's AR-15 had a red dot on it, which... if you know how a red dot works, the red dots project a laser holographically within the lens of the sight. The red dot doesn't project laser light that exits the lens in any way, and it doesn't project a red dot of laser light that actually falls onto a target. It's not visible to anyone else looking through the sight. And here I am doing the exact same hilarious, not gun person review of here's how a holographic laser dot sight works. I hope you all enjoyed that, as I enjoyed watching the defense attorney do that to the jury. Let's see here. So that was just kind of a point of clarification, again, to just put to bed any possibility that there was this minor allegation that Kyle had shined a laser sight at somebody. Basically, it was to show that it was impossible for Kyle to have done that, because that's not how red dots work. There was the two charges, as I said, against Dominic Black carry 6 years each. The defense attorney asked Dominic if the reason he is testifying against Kyle is to get leniency from the state in his charges. Now, Dominic's not exactly, I wouldn't exactly say that he's testifying against Kyle. However, the state is the person who, they are the entity that called Dominic as a witness. It wasn't the defense attorneys that called Dominic as a witness. It was the state. So typically, whoever's witness you are, you're colloquially considered to be testifying against the person who didn't call you. So being the state's witness, Dominic is colloquially known as testifying against Kyle, even though I don't think that his testimony really was vicious to Kyle in any way. I don't think that it hurt Kyle's case in any way. Certainly the revelation of the straw purchase isn't going to help anybody, but I think everybody kind of knew that that's probably what had happened anyways. So I don't know that was it was going to come out, right? So I don't think that mattered that Dominic testified that. I think that would have come out eventually anyways. Let's see here. So the defense attorney asked Dominic, was the reason that he had agreed to give up his Fifth Amendment right and to testify against his brother, was it because he hoped to get leniency in the trial where his 2 charges will be decided. Like I said, he's facing down the barrel of 12 years there. So was he hoping to get a lesser sentence by agreeing to testify against Kyle? Dominic said that there had been no promises of what will happen. Dominic testified that there was no plea deal, no deal that if Dominic testifies against Kyle, that the state would go more easy on him for the 2 charges of illegally providing a firearm that was used in a crime. When Dominic was asked by the defense attorney, let's see here. So Dominic says that he was not promised leniency, but he does hope. He hopes that his testimony will result in leniency on his sentence later on. Now, what's interesting is that the lawyer who is the state prosecutor, the lawyer representing the state and is prosecuting Kyle, that is the exact same lawyer that is representing the state against Dominic. So that's a little bit interesting. That's the exact same guy. So that might be why Dominic perhaps hopes that he will get some leniency later on in his trial a few months from now, though the state said that they would not provide him any leniency. So I guess we'll see what happens there. Dominic said that Dominic and his lawyer both met with the state attorney against Kyle, that was representing the state right now, before the case, but they never met with Kyle's defense attorney. Dominic was testified that he was not aware that the defense attorney for Kyle had offered a meeting, which that might be a little bit interesting. Again, I don't know if that's something that's going to come up or not, but basically what would have happened is that Kyle's lawyer would have reached out to Dominic's lawyer and said, hey, can we meet up and discuss what's going to happen at the trial? And Dominic's lawyer said no. Why? I don't know. I just thought it was interesting. Let's see here. So the picture I've got up on the screen here, this is a picture that came up during the cross-examination by the defense attorney. And they went over who all of the major players in this picture were. Again, I can't exactly remember which one was which. Obviously, you can see Kyle in the green shirt there. I believe Dominic might be the guy next to him with the blue shirt. I'm pretty confident that's Dominic, actually. So they knew the guy with the cross on his hat, but they didn't really know anybody else that was there. These are all just kind of, as they were, not necessarily random people, but just kind of citizens of the community saying, we're going to help defend these businesses. The Car Source owner ended up finding them at some point, and they decided, okay, we're going to defend Car Source tonight. And some of these other people decided the same thing as well, and they all kind of came together as this ragtag group of people who didn't really know each other before. Again, kind of like a zombie apocalypse movie, right? And I don't know, would you rather have zombies or Antifa? I don't know. Kind of almost like, 6 and half dozen on the other. All right, so this picture was rather striking to me because it kind of looks like a pre-battle picture, like the kind you'd see like in a war before some kind of like big operation where you're pretty sure everyone's going to die. And why? It just asks the question again. Why were these people in the situation where they're taking a pre-battle picture? Why? Because the state abandoned them. This whole situation is the embodiment of anarcho-tyranny. What is anarcho-tyranny? The anarchy is that the state abandons you to lawlessness, as they did in Kenosha for the nights of the riots, as they did in hundreds of cities all across America all summer during the riots. The state, again, the state being the word for government, a government abandoned these people to lawlessness. That's the anarchy. And then the tyranny part of it is that the state is now prosecuting based on how you acted during the lawless period that they abandoned you to. So it was basically like the purge. There was just no laws in Kenosha for about a 6 to 12 hour period. The state had abandoned them to anarchy. Then the next morning when the sun comes up, you have the tyranny. The boot of the state comes down to judge you on how you acted during the 6 hours of lawlessness. And the tyranny right now is attempting to grind Kyle into dust after having abandoned him to anarchy. That is the core. This is the perfect example of what is anarcho-tyranny. Like, this is a practical embodiment of it, not just a academic definition, but this situation is itself a practical story of what actually happens during anarcho-tyranny. Well, what happens during anarcho-tyranny is that you're forced to join up with other strangers that you don't know, pretend, looking like you're in some kind of zombie movie, to defend businesses against people trying to burn it to the ground. And then the next morning, the state doesn't come to help the people who had their business burned down. No, they come in to prosecute the people that tried to defend the ones that didn't burn down to the ground. Kyle should be judged. I've said this a bunch of times, and I'm going to keep saying it. Kyle should be judged by the laws that were in effect that night. I think that this image captures that they were definitely in what amounts to a war zone. There was no laws that night, and Kyle should be judged by that standard. Dominic, let's see here. So they continue talking about the timeline. This is again still the Kyle's defense attorney cross-examining Dominic. Dominic said that they started off by defending the car source that you see in the image here. And there was multiple locations that car source owned. There was a franchisee owner that owned it with a partner, and they had like 4 or 5 lots in the city, and at least one of the lots, I think 2 of the lots, had like their entire inventory of like 100 cars absolutely burned to the ground the night before. I mean, you can imagine how much money that is. You on average, you're looking at like 10 grand per used car, and just having 100 of those burned to the ground. Let's see here. Not to mention one of the buildings was actually like just turned to rubble. Somehow which that's pretty wild. That like, I mean, a fire, I understand like fire is pretty bad, but like just like a 1-story stone building, and like somehow like a fire like just completely turns the foundation to dust. It really looked like a bomb had gone off, even though it was just fire. It was just so much fire that I guess stone crumbles. So they started off there, and Kyle was on the ground, walking the parking lot, and Dominic and some other people had gone to the roof. And they were, as Kyle would put it in one of the video interviews that he did prior to the shooting, as Kyle put it, they were providing overwatch, which overwatch is a military term for somebody who is in a higher position, overwatching the guys on the ground performing whatever the operation is. And so again, it's this militaristic atmosphere. It's this urban combat environment. Why? Because the state abandoned them to lawlessness. They abandoned them to anarchy. All right, so at some point, Dominic or Nick Smith is this other character whose name comes up a lot. We're not exactly clear on who Nick Smith is, other than just from the discussions during the testimony. I'm pretty sure Nick Smith at some point will testify, so at some point we'll get a better idea of who he was and what his side of the story was. But Nick Smith is somebody who was associated with Dominic and Kyle that night. So Dominic testified that either Dominic or Nick Smith had called Kyle at some point. Dominic couldn't remember which one, and told Kyle that one of the other car lots was unguarded and potentially being attacked. At this point, Kyle headed south. He left the car source that he's at currently in this picture. He had left it to go to the other one that was a few blocks away to the south. As we know, eventually he would at some point try to make his way back to this car source, make his way back to Dominic, but he was blocked by a police line who would inevitably send him back in the direction of Rosenbaum, where we know the rest of the events of that night would unfold. But we now know that it may have been Dominic that had directed Kyle to leave to go to the second location to begin with. At least we know that somebody had directed Kyle. He hadn't just walked that way on his own. Somebody had directed him to go there. Dominic says that he was up on the roof, and so he could see Kyle leave the first car source, but that pretty shortly after he left, got down the street a little ways, Dominic was no longer able to see Kyle. He could see him walking in the direction of the second location, but he couldn't see the second car source from the roof of the first one. A few minutes later, he sees Kyle walking back. It was several let me back up here for a second. So Dominic can see Kyle walking away to the second location. At some point, Dominic says several tens of minutes later, after Kyle left, from the roof still, Dominic hears gunshots ring out. A few minutes later, after the gunshots ring out, he sees Kyle walking up the street towards the police line. This would have been the second time Kyle approached the police line after he had shot Rosenbaum, after he had shot Anthony, after he had shot Gage, and shot at Dropkick Man. Dominic sees Kyle with his hands in the air, attempting to turn himself into the police line and being turned away. At that point, Kyle makes his, and this is all Dominic's testimony, at that point, Kyle then makes his way back to Dominic and the group, where he describes, at the first car source, where he describes to them what happened to him, and we pick back up with Dominic driving Kyle back to his house in Antioch, and then eventually going to turn himself into the Antioch police. The defense attorney asked Dominic if Dominic wanted Kyle to have a gun during the situation. So this gets into the question of, okay, so how did Kyle get the AR-15? Well, Dominic's stepdad had opened up the gun case. Okay, why did Kyle, that doesn't really answer the question. Why did Kyle have the AR-15? So the defense attorney asks Dominic, did Dominic want Kyle to have a gun during the situation? Did Dominic knew that later that night they were headed out into town to defend local businesses? Dominic had already testified that Dominic felt that he needed to have a gun for personal defense. We had already established that these two boys were close enough that they considered each other brothers. So the defense attorney says, Dominic, you consider Kyle your brother. You thought that you yourself needed to have a gun for self-defense. Did you think that Kyle needed to have a gun for self-defense? Dom testified that he was ambivalent about whether or not Kyle had a gun. I don't necessarily think that's true. I would guess that probably Dominic wanted Kyle to have a gun. I'm guessing it wasn't just a neutral ambivalent. It doesn't really matter one way or the other in the heat of the moment. Now, maybe on the stand, that's how Dominic would like to play it. But I think the deeper truth is probably that, yeah, Dominic probably was like, yeah, I'm okay with him having a gun. I know if somebody I considered to be my brother, if I felt I was in a situation where I needed a gun for self-defense, and I was with somebody who I considered to be a brother, I would also want them to have a gun for self-defense. I think you guys can probably do that own calculus for yourself in your head as well. Let me take a drink here. Let's see here. Alrighty, so there's just like personal thoughts while watching. Dominic, I don't see him as a bad guy here. I'm really seeing Dominic and Kyle throughout the story unfolding here as really kind of a battle buddy mentality dynamic that we've set up here. Of course, I think obviously Dominic wanted Kyle, his battle brother, to have a gun for self-defense. Pretty obvious. And I don't think that's a that's not morally problematic. That's perfectly fine. And on the day, let's see here. And on that day, it wasn't necessarily a problem legally. Why wasn't it a problem legally on that Tuesday? Well, as I said, the state had just abandoned the city to lawlessness. So if, the rioters and looters don't have to follow the laws about burning people's shit down, why should Kyle have to follow the law about whether or not he can have a gun? Again, this is a moral argument. This is me speculating and philosophizing, if it were, not a legal argument, because I'm not a lawyer. And this is not a legal show. But it is my opinion that there's not a problem with Dominic wanting Kyle to have a gun, and there's really no problem with Kyle having a gun morally. Again, this case is legal, but sometimes you got to analyze it from the moral perspective as well. Let's see here. Cross-examination. Cross-examination, which again, Kyle's defense attorney talking to Dominic, they asked Dominic about a statement that Dominic had given to detectives late night / early the next morning after Kyle had turned himself in. Dominic described how gas, like tear gas containers and rocks and other projectiles were being thrown at him up on the roof. Again, it kind of paints this picture of a war zone, some kind of urban combat environment, kind of a zombie apocalypse type of situation. Dominic testifies that Kyle provided first aid to multiple people and put out multiple fires that night. These guys had to take on, this is again about personal thoughts here. What Dominic's describing and what we've seen from the videos that night is that these guys are really taking on the role of EMTs, of the fire department, of the police, of public sanitation. Why? Because none of these civil services were being provided by the city anymore, because the city of Kenosha had been abandoned to anarchy. EMTs weren't running that night. The fire department wasn't running that night. The police were defending the police station barely, and not providing any security to the rest of the city. You even had the state police and sheriffs and police departments from surrounding cities there, none of them providing city to the security itself, but just making sure that the purge didn't leak out of the borders at all. So because the state abandoned the city to anarchy, these guys had to take on the role of EMTs, fire departments, and the police. And after forcing these guys to take on the civic burden of all these public services, now the government is prosecuting Kyle and Dominic because they didn't implement these civil services the perfect way that the state would have done it. Well, the perfect way the state could have done it was just to implement them at all, but yeah, the state was scared that night, so they didn't feel like doing it. So having abandoned Kyle to that stuff, having abandoned Dominic to that stuff, now the state is Monday morning quarterbacking and deciding, oh, well, I know that we abandoned you, but now that we're back, we're not very happy about how you acted after we abandoned you. That's, again, Kyle should be judged by the laws that were in effect that night, which was none. Let's see here. Because I wrote this in the notes too, was this is not about, I don't think of this case, obviously this case is about the charges that are out there, but I think the broader context for this case is that it's not about whether or not Kyle broke the law that night. I think that this case should be about, were there any laws at all that night? And I think the answer was no. Let's see here. The state examined Dominic again. They just did a quick re-examination, asking Dominic some questions. They asked Dominic again, who told Kyle to leave the first car source and go to the second car lot? Was it Nick Smith? Was it Dominic? Dominic replied, I don't know. He can't remember who told Kyle to leave. Now, maybe that's something that Kyle will testify to. As I said yesterday, it appears that there's currently Kyle plans to testify, which means that he'll be examined both by his defense attorney and cross-examined by the state attorney. So I guess we'll see. Maybe that's a question Kyle can answer when he testifies. Kyle can still reserve the right to not testify, so maybe he won't, but at some point in the next 2 weeks, it is highly likely, or at least seems probable, that we will see testimony from Kyle, which will be very interesting. Alrighty, that was Dominic's testimony. We have so this is still from yesterday, from day one. Later, after Dominic left the stand, there was a witness testimony. Let's see here. Oh, there was that. Okay, so actually there was another person that testified yesterday. So we had Dominic, and then we had an unknown person testify. Whoever this person was made a deal with the state prosecutor that they would not be recorded. So I was watching a stream provided by Court TV, who has cameras in the courthouse and is providing audio and visuals for it. That's who's providing the feeds that any stream is using right now. There was some kind of deal with the second witness where they were not to be video recorded. So I don't know what they said. Nobody knows what they said. I'm sure that there's some people, journalists in the courtroom who got some of the cliff notes of what he said, but I don't know what it is, and I haven't had time to look at those sources yet. The witness after that, when the cameras were turned back on, so the third witness, this is still on day one, was Corey Washington. So Corey Washington was brought by the state prosecutor. He's the state's witness, and the state examined him first. There was, let's see here. They started off with some initial discussion without the jury present, that the defense was not going to be allowed to bring up Corey Washington's criminal history. So they brought Corey Washington up, but they didn't bring the jury in quite yet. And there was some discussion between the lawyers and the judge that Corey Washington presumably has a rich criminal history, and that the Kyle's defense attorney was not allowed to bring up that criminal history to try to impugn the character of the witness. I'm not sure if that's going to be relevant, though I suspect that it could be later on. I ended up being wrong on that, at least from what I could see. By the end of Corey Washington's testimony, it didn't really seem that was relevant one way or the other, whether or not he was a criminal, though it may have colored a little bit of his commentary. Corey Washington, after they brought the jury back in and the state started questioning him, they asked him about his job, and he seems to be a fellow. He describes himself as self-employed as a social media influencer. He says that he regularly live streams and provides commentary, which what a bum. Get a fucking job. People who just live stream all the time and give commentary on political situations. What total scumbags. I wouldn't trust anybody like that. They should kick him off the stand. And he was live streaming on the night of the riots. He had been this being Tuesday night, the night of Kyle's incident, having been Tuesday night, the third night of riots. Corey Washington had been live streaming all 3 nights. Corey Washington characterized the riots all summer as protests. Now, I wasn't going to mention this, but Corey testified as such, unprompted, that Corey Washington is a black man. He testified that he's black. He volunteered that information without being asked. So I think it was rather obvious to everybody in the courtroom, but he decided that was an important enough characteristic that he unprompted told the court about it. So I feel comfortable in having mentioned that he's black as well, and that may have colored some of his maybe that was probably a bad choice of words. That may have framed his perspective on the riots throughout the summer and his framing of them as protests, probably because he supported Black Lives Matter. Corey Washington said that when he saw burning garbage trucks in Kenosha, he realized that the Kenosha riots were different than anything he had seen before all summer, which, in my mind, that pegs him as having not paid attention all summer. Sure, Kenosha is summer 2020. Remember, throw yourself back to summer of 2020. COVID, wildfires, riots. That was all summer. Kenosha happened at the end of August. We had the entire summer before the end of August. So Corey Washington said, seeing the burning garbage trucks in Kenosha, wow, this is different. This is worse than what we've ever seen all summer. And sure, Kenosha was a particularly bad event for the summer of 2020, but I wouldn't consider it to be a novel event. It was different in the fact that it was, wow, this one town, they really burned this entire town to the ground, but it was a small town. But the type of destruction had been happening all summer. It's just harder to burn down the entirety of Minneapolis, though they did try. It's harder to burn down the entirety of Portland. These are big cities. Kenosha is not a big city. You burn down 2 or 3 blocks and you've got half the city down. And so I just think that Corey Washington right off the bat, he just outed himself as having not been paying attention or being extremely biased in how he views things. Corey Washington testified that he had seen a black-clad individual trying to burn down Kenosha's Dinosaur Museum, which I don't know why the hell we're so hung up on Kyle Rittenhouse killing a pedo. The case of Kenosha should be, who was burning down the Dinosaur Museum? How could they? How could you? Why? Why? Is there nothing sacred in this world? The Dinosaur Museum, of all places. Let's see here. So this is where I'd made a note, too, where I had realized I was wrong yesterday, that the incident for Kyle was not on the second night of riots, but it was on the third night of riots. Corey Washington had corrected me on that. Corey Washington is... Also, all of his videos are live streamed in portrait mode. So like I said, I think that he had kind of outed himself initially that he wasn't somebody who paid very good attention to national events, by having thought that Kenosha being on fire was new for the summer of 2020. But if you had any doubt in your mind as to whether or not he was a fucking moron, he professionally live streams in portrait mode. Absolutely criminal. He had the video of a burning dumpster. There's a rather well-viewed video of a dumpster on fire that Kyle would eventually put out. It is a dumpster that is presumed to be the one that was on fire. Kyle put it out, and that is what set off Rosenbaum to be upset at him. The video of that dumpster on fire is actually the one that Corey Washington took. So it's a video I recognize. It's probably a video that you'd recognize too if you were watching the trial. And that was actually taken by Corey Washington. You can see in the video. Oh, well, thank you, Garand Wolf, for following. Much appreciated. You can see in the video that Corey Washington took that gas was 209 in August of 2020. So let's go, Brandon. Also, Corey Washington looks suspiciously like Childish Gambino. I'm not saying he is Childish Gambino, but he might be Childish Gambino. All right, at that point in the testimony, they decided to take a break, and then they decided to call it a day. So this was the end of day one, and we're now on to day two, where day two started. That was today. Started about 9 a.m. Eastern. Actually, I think it was 9 a.m. Central, possibly. I'm not positive on that. Let's see here. So the court immediately picks back up with the state of Washington examining and questioning Corey Washington. The state of Wisconsin prosecutor examining Corey Washington. A lot of state names here. Let's see here. So we watch a long video of probably about 10 to 15 minutes worth of video of the gas station. During the video that Corey Washington was shooting, we see Gage, the guy who was disarmed. We see Kyle. We see Anthony Hubert. So kind of all the major players of that night are in and around this gas station over the course of about 15 minutes. Let's see here. Corey also had a shot, he also had a view from rather far away of the parking lot where the first self-defense shooting occurred. You can hear in the video how quickly the shots rang out. Again, it was testified yesterday that Kyle had shot 4 times over the course of 0.7 seconds. That's really fucking quick. That's really, really quick. And you can, I know I've tried to speed shoot, and it's real hard to get going that fast. I don't think I could possibly go that fast with anything but maybe a 22. And Kyle's doing it with a pretty decent sized AR, shooting 223, which we also found out that he was shooting 223. I'll get into that in a second. Let's see here. So Kyle, at this point, the state rests their case with Mr. Washington, and Kyle's defense attorneys pick up cross-examination. Their first question, again, this is Kyle's defense attorney. Their first question to Corey is, did Corey get a curfew violation ticket for being out that night? To which he answered no. Now, I believe that this was just a relevant tidbit. I don't think it's going to make or break the case, but I think it is an interesting factoid because Kyle is part of... I don't want to say this because I'm not sure positively. I know that there's a complaint that Kyle was out past curfew. I don't know if one of the charges is related to curfew or not. I think it might be enhanced by it, though. But I think that what the state may want to do is try to tell the jury, hey, Kyle's a delinquent. He was out past curfew. Had he not been out past curfew, he wouldn't have done all these other things. So you should get him on that. But I believe Kyle was given a ticket for curfew, or Dominic was. But at some point, Kyle and Dominic had come afoul of the curfew violation, and they'd gotten tickets. And for some reason, Mr. Corey Washington, portrait mode live streamer, did not get a curfew violation ticket. He should certainly get a portrait mode ticket, though, if there was such a thing. Corey Washington describes that many in the crowd appeared to be out-of-towners. Corey is actually from Kenosha, so he was generally familiar with the people. Also, this being the third night that he had been out, he was generally familiar with the townies, and he had noticed that there was a lot of people out during the week, during the 3 nights of rioting, that appeared to be out-of-towners. The defense, give me a second here. The defense attorney for Kyle, they built a pretty nice little legal case here over the course of a few sentences, and I actually didn't see it coming, though I probably should have. So previously, the state had asked Corey, were there any fires at the car lot where Kyle's first shooting incident happened? Now, you'll remember that the car lot where Kyle shot Rosenbaum at was the car lot that he had gone to after leaving the original Car Source lot. Now, the original Car Source lot, they were defending, and the reason why Kyle had gone to the second location was because there was no one defending it, and presumably somebody was going to attack it. So the state attorney had tried to dissuade that notion by asking Corey, well, was there any fires at the other car lot that anyone should have been worried about? As if to suggest that because there wasn't a fire already, that meant that there was never going to be a fire, even though we've got the evidence of the previous 2 days where they had burned hundreds of cars down. So Corey had said, no, of course not. There was no car fires. Car fires, of course not. No, he really just said no, there was no car fires. But that's what the state was trying to imply, that, well, if there was no car fires, and there never was going to be car fires, because that's how car fires work, apparently. So Corey had testified, no, there was no car fires in the lot. And that there was much less fire generally on Tuesday night, the third night. There was much less fire generally on Tuesday night, the third night. And I thought that the state was trying to make the case that there was no fires and no reason for Kyle to be out protecting the lot, as I just said. But the defense actually got Corey to say that perhaps there was a correlation between the number of people out on Tuesday night protecting businesses. Because what they did was they set up Corey and said, hey, okay, so you were out on all 3 nights. Yep. Was there a lot of fire on Sunday? A lot of fire. Was there more fire on Monday? Yes, there was more fire on Monday than there was on Sunday. What about Tuesday? There was less fire on Tuesday than there was on Monday or Sunday. Okay. Then they asked him, was there people out defending their businesses? Was there a lot of people out defending their businesses on Tuesday night? Yes, there was a lot of people out defending their businesses on Tuesday night. Was there more people defending their businesses on Tuesday night than there was on Monday night? Yes, there was more people out defending their businesses on Tuesday night than Monday night. And so then the defense attorney says, so what you're saying is that on nights where there was less people defending businesses, there was more fires, and on nights where there was more people defending businesses, there was less fires. And Corey got very huffy, having realized that he got tricked into making the defense's case for them, and got very huffy and tried to say, well, not exactly, though he couldn't describe why it wasn't exactly that. And that's a very good point. The defense said more people protecting businesses equaled less fires, and I think that is a very compelling line of logic to give to the jury. The defense attorney asked Corey to characterize Kyle's behavior on Tuesday night. Corey Washington responded that Kyle was chain smoking. Corey had earlier described Rosenbaum's behavior as erratic. So the defense attorney had kind of a funny quip back at Corey Washington saying, so what you're telling us is that Rosenbaum's behavior was erratic and Kyle's behavior was chain smoking. Are you sure you're answering our question here? And then Corey got huffy again, probably not very happy that he was getting taken out by the defense there. The defense brought back up that Corey had stated that there were no fires in the car lot where the shooting took place. The defense, Corey agreed that, yes, there was no fires in the car lot where the first shooting took place, as the state had previously attempted to posit. And then the defense attorney proceeded to play a video of a fire in just exactly that car lot, which calls into question for the jury all of the verbal testimony that Corey gave that night. It leaves only Corey's live video footage as real evidence. But everything Corey said that night, clearly this man does not pay attention to his surroundings. Even in the middle of a war zone, he's not paying attention to his surroundings. They showed him a video of a car on fire in the lot that he was in, from his own video, I think. And he had testified, oh, there was no fires here. Well, are you sure? Because there appears to be a fire here. Are you sure that Kenosha was the first time rioters had burned down a city in the U.S. that summer? Maybe you're not. Maybe you're not somebody who pays attention very much. Or maybe you do pay attention, and maybe you are just intentionally lying for unknown motives. But the state, or the defense attorney, did a very good job of, I think, in my opinion. Now, I'm not a juror, and I talked yesterday about how we have a problem of selecting uncritically thinking, dull jurors in this country. Not to say that I know exactly the type of people that are on this current jury, but statistically they're dull, uninformed, and not critical thinkers. I went through more of an explanation and justification for that thought yesterday. I'm just going to leave that there for right now, though. I thought that what the defense did with Corey Washington to kind of debunk Corey Washington and to say, here's a bunch of examples of where you've got poor judgment, where you're not paying attention to your surroundings, and where your verbal testimony is really called into question, that you're not somebody who's able to properly perceive and categorize the events around you. His video footage in portrait mode, that speaks for itself, but Corey Washington's words, well, they're probably not very reliable. I would, as a juror, notice that. Whether or not the jurors in Kyle's case notice that, we can only hope. The defense attorney rests their case. The state goes back to examine the Corey Washington again. They attempt to... the state attorney attempts to posit that Rosenbaum taking his shirt off and putting it onto his face, that possibly he was using it as a COVID mask. The defense decides to unrest and get back up to cross-examine, and says to Corey Washington, now, I know what the state just said, but you don't really believe that Rosenbaum had taken his shirt off, put it over his face to be used as a COVID mask, do you? And I think Corey said something to the effect of he wasn't sure what was going on in Rosenbaum's head, which is probably the most accurate testimony he gave that day. But it was just funny that the state was trying to make up this story that, well, the only reason why Rosenbaum took his shirt off and put it over his face after being out in a riot for 4 hours, that he was doing that because he was scared of COVID. I don't know. That doesn't really check out, but Rosenbaum was crazy, so it's hard to say. Let's see here. After that, they are the state and the defense are done with Corey Washington. He is relieved from the stage, and Detective Martin Howard, I almost said Howard Martin. Detective Martin Howard is brought up on the stand, and he's the last witness that we're going to be talking about today. Let's see here. Detective Martin Howard was brought on by the state. The state prosecution brought him on as a witness, and they questioned him first. Martin Howard is a detective in the city of Kenosha. Martin Howard was a detective during the riots, and he was out in an unmarked car throughout that day and that weekend watching the crowds. Presumably, Detective Martin Howard was watching the crowds terrorize the people that he swore an oath to protect. Detective Martin Howard is, in my opinion, an oath breaker. Detective Martin Howard testified that the city had made a choice to turn off gas pumps at gasoline stations on Tuesday night around 6 p.m. This was in order to prevent the gas being used to start fires, as had been done previous nights. Around 12:30 a.m., which is about 40 minutes after the shooting. The shootings took place about 11:45 to 11:55 p.m. on Tuesday night. So we're now at 12:30 a.m. on Wednesday morning, about 40 minutes after the shooting. That is when Detective Martin Howard was assigned with a partner to be the lead investigator of the homicides that had occurred 40 minutes earlier. And he testified that he remains the detective on this case currently. Let's see here. He said that primarily his investigation initially involved saving videos off of social media. He went to go see Kyle Rittenhouse early in the morning on Wednesday, where Kyle was being held after turning himself in. Let's see here. He described Kyle's injuries the night of as a half-inch scratch above the eye. He described other, quote, scratches around Kyle's body. And I believe that using the word scratch was inappropriate for a detective to be saying from the stand. I believe the technical term for a scratch would be an abrasion, and a detective would know and understand the nuance of that language. Categorizing it as a scratch really softens the connotation with the injury. It's like, oh wow, you're complaining you shot somebody because you got a scratch. Come on. An abrasion would have been the proper medical term to use, and it wouldn't have added a inappropriate classification or an inappropriate connotation, an inappropriate judgment of the severity of the injury. He should have used the word abrasion and not the word scratch. I think that he probably knew that he was using the inappropriate word. He was possibly coached to use the inappropriate word. Again, this is a word that should have a medical and legal definition that a detective should be well aware of and well aware of the reasons for using it. And him saying scratch instead of an abrasion, I think was an intentional way of trying to bias the jury to say, oh, Kyle's injuries weren't that bad. It was just a scratch, and he killed somebody over a scratch. Let's see here. The detective goes on to describe other injuries that Kyle had sustained, that the detective was able to surmise over a visual investigation over Kyle. This was, again, the night/early morning of the shooting. The detective testified that Remington .223 casings were recovered from the scene. It was speculated widely by a lot of people. I also agreed at the time that Kyle was likely shooting .223 on that night rather than .556. Having some experience in the difference between the calibers myself, .556 typically packs a lot more punch, resulting in a more consistent muzzle flash. Basically, every time you fire .556, you're going to see kind of a flash and an explosion coming out of the barrel. You might get it with .223 every now and then, but you get it consistently with .556. And from what I could see of the video footage that was available, Kyle's shots did not have the type of muzzle flash I would expect to be produced by .556, especially on a dark night. So is this really important to the case? Not at all. I just think it's fun trivia because I was able to visually guess what kind of ammo he was shooting out of his AR-15, and it's now been confirmed that just as trivia that Kyle was shooting .223 that night, not .556. Let's see here. At one point, the state... oh, this part was fun. Okay, so the state prosecutor attempted to play a video of one of the live streams, one of the many live streams that had occurred that night. The videographer... Now, we had just heard from Corey Washington, who was also a live streamer that night. We were... Corey Washington's footage was admitted into evidence, was referenced as evidence, and then Corey Washington was brought in and testified on the stand. Now, this other video from a different live stream that the state wanted to play for the detective had a lot of commentary over it. The person that was filming, also I think in portrait mode, was talking a lot about what he was seeing, which is fine. He's a live streamer. He wasn't filming this for the court. He was filming it for views, right? But the state chose, they had the option to, the state chose not to invite the videographer as a witness. but this videographer has their commentary overplaying the entire video. So the defense objected. This was very fun court maneuvering that was going on there. The defense attorneys objected to playing the video. I object. And they said that they could play the video but not the audio due to the commentary from the filmer. This is because the filmer is not being called as a witness, during which the defense could have asked questions to clarify and challenge the commentary that was being presented in the video. Basically, because all the commentary in the video is making observations about what's going on and what's happening, the commentator is not being admitted as a witness. So it constitutes as kind of like an outside influence as to what's going on. And the defense is unable to respond to what is being said because this person is not a witness that the state can cross-examine. They just have to listen to this recording and hope that that's correct. The judge agreed that this constitutes hearsay, which is not admissible as evidence. And I might play it at another time, maybe to close us out here. But the judge agreed that this was could not be played the way that it was, and that they could do it if they did not play it with volume, if they muted it instead. The judge said, quote, "A statement of a non-testifying person cannot be offered to prove the truth that is asserted in the statement." So basically, what the state wanted to do was show this video of the chaos that was going on with the commentator describing it verbally. And the judge said, well, his description of what is going on, it's not proof that that's what was going on, because he's not here to testify it. For him to be, he could, if the state had invited him as a witness, the judge said you could have put him under oath, he could have been cross-examined, but as it stands, his commentary cannot be admitted as evidence because his commentary wasn't provided under oath. It wasn't provided with the ability for Kyle's defense attorney to cross-examine it. So had the state brought this person as a witness, they could have perhaps done what they were trying to do, but instead they couldn't. So this resulted, the resolution to this objection initially was to play the video without sound, though the state would go on to break that rule here in a second. So the video showed Kyle, Dominic, who we heard about earlier, and several others guarding the original car lot that we're seeing in this picture that's on the screen right now. Even though the state was supposed to mute the video, they still played audio for selected portions, trying to catch where Kyle Rittenhouse was speaking or could be heard speaking on camera. However, the commentator, that was the reason why they were told the video had to be muted, the commentator could still be heard multiple times, asserting that Kyle was a member of a militia and asserting other things about what it was that Kyle was doing. Again, this wasn't Kyle saying it, this was the commentator that the state did not bring in as a witness. And while the statements that Kyle is part of the militia may or may not be true, it's a statement asserting a fact to which the defense is unable to challenge because the commentator is not present to be cross-examined. So essentially the state is trying to use this YouTube clip to frame Kyle as a militia member, and the defense has nobody to cross-examine to refute that, which is not fair. The state kept trying to play the commentary like this, where they were, we're just trying to listen to what Kyle's saying. Like, oopsies, I guess we pulled in some of the commentary on that too. And so they ended up receiving another objection by Kyle's defense attorney. The judge, let me see here. The judge kept saying that it was hearsay. They went through this kind of lengthy review process of searching up the definition for hearsay in the legal books and figuring out if it was or wasn't, and they went back and forth challenging it. The state finally admitted that their intention wasn't just to play clips of Kyle Rittenhouse's speaking during the video, but their intention was to play the commentary as it was, and that their intention was that the commentary be used as evidence in the case, which you can't do. If you want somebody's commentary to be used as evidence, you have to invite them as a witness. You can't just play a recording of them. And let's see here. They said that the reason why they wanted the commentary admitted as evidence was because it was describing the situation, which is, again, perfectly fine if they wanted to bring the filmer in as a witness to describe the situation under oath and to confirm that his commentary at the time was accurate. But as it stands, really the state could have been playing clips of Dyer and me commenting on the scene and admitting our commentary as evidence. It would have been just as valid because it doesn't matter. We're not under oath. We can say whatever the hell we want. When we're not under oath, it doesn't matter. So it was irrelevant that the state thought that he was describing the situation as it was. Again, it would have been as appropriate for the state to play a video of me describing the situation. Again, that doesn't seem very much like it would make very much sense if I'd be the one describing the situation, but it doesn't make sense for them to just pick a random YouTuber and have them describe the situation either and try to admit that as evidence. It's ridiculous. Let's see here. It was a really underhanded tactic by the state, and hopefully this means hopefully it means that the state relying on underhanded tactics, hopefully they're relying on underhanded tactics because they don't actually have a good case, and they know that. And so, them needing to rely on deception and tricks to make their case, that could bode well for Kyle in the future, as this is going to be a very long trial. 2.5 weeks is what it's projected to be, which is not a short trial. It's not the longest, but it's not short. If they're already on day 2 reverting to tricks and deception to try and make their case, then they're going to have a hard time filling 2.5 weeks with like proper legal arguments. That's for sure. The judge was pretty angry about this. Well, I'd say that he's angry. He was just unpleased. And so he actually sent the jury out of the room so that he could have a more candid conversation with the prosecutor and the defense attorney. The state tried to assert that the commentary of the filmer is proof of Kyle's state of mind. So I want to play this clip later. I'll have to find it. I'll probably do what I did yesterday where I'll play this clip and let it kind of play out the show. But basically, the state was trying to say that the commentary of a YouTuber proves Kyle Rittenhouse's state of mind, which is ridiculous. So just a random YouTuber that they picked giving commentary on the scene. The state wanted that to be admitted as evidence of Kyle Rittenhouse's state of mind. Completely absurd. At some point during this exchange between the judge and the two lawyers, the judge called out Jeffrey Toobin of CNN, which was funny because I guess Jeffrey Toobin made a very stupid comment about the first day of trial, and the judge felt the need to clarify that. Was it the most appropriate thing for the judge to do? No, but it was really funny. At that point, the feed cut out, and it's unknown what was said. The feed was intentionally cut out. So there was some discussion about the situation that was had off camera, and we don't know what else was discussed. The video came back, and the examination of the state prosecutor asking questions to Detective Martin. What the hell's his name? Martin Howard. Let's see here. So they picked back up examining Martin Howard. They started playing a different video instead. I believe they gave up on playing the first video, and they've now moved on to another video. This video showed an MRAP giving somebody a sheriff or a police officer, SWAT member, somebody popping out the top of an MRAP, giving Kyle a water bottle. This video circulated throughout the last year. A lot of people say, the cops are giving Kyle water. Yeah, how dare they? The MRAP did not belong to Kenosha, and so the detective said that it must have belonged to an unknown sheriff's department. So they actually, it is interesting that we're looking at like 14 months later, and a detective for the city of Kenosha doesn't know which sheriff's department had an MRAP in his city on that night. on the night of a murder case that he's a double homicide that he's in charge of, and he's not aware of which law enforcement groups were active in the area that night. That's interesting. So I guess it wasn't just anarchy for the citizenry either. I guess the police, in their unorganized effort to not keep law and order, were also disorganized in their efforts to do that, because they apparently had multiple groups come in from other cities, and they all did fuck all, except for drive around MRAPs that you paid for. Let's see here. They looked at several more videos with the detective. Again, there's a lot of these videos that you've probably seen before over the last year. They played a video, which we've all definitely seen, of Kyle being interviewed earlier in the night. Kyle described that he had been providing aid and that he had a firearm on him for self-defense against that he and the other people that had weapons were using them or had them to protect their own lives. Again, this is civilians needing to take over what should be civil services. This is Kyle having to take on this approximation of being an EMT, an approximation of being a fireman, an approximation of being a police officer to enforce law and order. This is civilians being forced to take on approximations of civil services because the city and the government abandoned them to anarchy. And because that night was lawless, Kyle should be held to the standard of lawlessness. Yet the state, after abandoning Kenosha to the purge for 6 hours, as soon as the sun came back up, the state says, well, we're going to judge Kyle by the laws that weren't in effect at that time. Ridiculous. Let's see here. They played a video from the first shooting again. This video shows Rosenbaum clearly chasing Kyle, even though the state had lied in their opening statement saying that Kyle was chasing Rosenbaum. We can clearly see Kyle running, followed by Rosenbaum running. I mean, I don't know. I don't chase people very often, and I haven't been chased very often either. But typically, the way you chase somebody is that they're in front of you and you're behind them and you're chasing after them. If you're in front of them and they're behind you, they're probably chasing you. You can't really chase somebody in reverse. It doesn't work like that. It's one of those things that only works in one direction. Let's see here. So the video that they played also allegedly it also shows alleged journalist Richie McGinnis rendering aid to Rosenbaum after Kyle shot him. Funny because period, next sentence. Another funny thing that happened during the video is that because they're pulling YouTube feeds, right? There's actually a super chat that popped up that said they found out, and it read it out, which is kind of funny. Obviously referencing the fucking around find out meme. And so right after Rosenbaum got shot, somebody super chatted, they found out. And that was admitted as court evidence, which is fun. Let's see here. You can also see a car in this video. You can also see a car burning in the lot around the corner, and the car is like pretty much engulfed in fire. And this video is like only a few seconds after Rosenbaum was shot. So again, the state was trying to build up this idea that there was no cars on fire at the second location. So there was no reason for Kyle to go there to defend it because there was nothing that needed defending. Yet in a lot of these videos, you see, oh, yeah, they are actually attacking the second location. And because there wasn't very many people there to protect it, there are cars burning down. So I don't know what the state's trying to go for there other than just hoping people don't notice that that's the location where they said there was no cars burning, but there was cars burning there. I noticed. In another video that the state showed and went over with, again, they're talking to and asking questions of this detective, and they're showing him videos, asking him questions to clarify, is this that person? Is this that location? Trying to reestablish all of their facts of the case and all of the facts of the sequence of events that night. That's basically what they're doing with these videos and the witness testimony at this stage of the case. They showed another video which had a remarkably clear angle of the first shooting. It was from behind Kyle, and or no, it's from behind Rosenbaum, because you got Kyle running, Rosenbaum pursuing him, and then this camera is a little bit behind and to the left of Rosenbaum. And so you have this remarkably clear shot of Kyle running, being chased into a corner by Rosenbaum, turning and shooting Rosenbaum. So that was very, very clear angle. I think I'd maybe seen that clip before, but not very many times, because it was definitely, I was like, wow, that's a very, very clear shot. Let's see here. Went through the 8 shots that Kyle fired that night. So Kyle discharged his AR-15 8 times that night. No, he did not. Hold on a second. Let me back up here. So Kyle did shoot his AR 8 times that night, but this is not what I'm talking about at this moment. So let me back up here. So the defense attorney is showing a video. No, sorry. The state prosecutor is showing a video to the detective in which there's 8 shots that are fired off. This video covers the period of time when Kyle shot Rosenbaum. There's 8 shots that can be heard in the video. And so the prosecutor goes through what each of the 8 shots are. The very first shot that's fired is shot by somebody named Josh Zeminski, who fired a pistol into the air. So that's shot number 1. 2.5 seconds later, there are 4 shots that go off over the course of 0.7 seconds. That's Kyle shooting Rosenbaum 4 times. There's 3 more shots within a couple of seconds of Kyle's 4 that are shot from somewhere else. The state prosecutor and the detective are not sure where those shots came from. They believe it was from the next street over, though the casings were recovered. They don't know who shot it. That person remains unidentified. It's not clear what they were shooting at, why they were shooting, who was shooting. They just know that there was 3 additional shots that did not belong to either Kyle or Josh Zeminski. Though, again, it's widely believed that Josh Zeminski just randomly firing his pistol into the air, that is what kind of triggered Kyle to turn around and shoot Rosenbaum, believing that perhaps he was in danger. We don't know that for sure. Perhaps Kyle will testify to that effect. If that's true, that will prove that that will make it very difficult for the state to prove that Kyle did not think his life was in danger. Let's see here. The next video that they showed shows Kyle heading back towards the police line after having shot Rosenbaum. This is where he is chased by Gage, Anthony, and others. You can hear the crowd yelling, "Get his ass." You can hear them yelling that as a mob forms, chasing Kyle Rittenhouse down the street. If that sentence on its own, just the mob yelling, "Get his ass," and then chasing him, if that's not probable cause for self-defense, I don't know what is. I think that is so clear-cut that the state is unable to prove that Kyle's life was not in danger. The burden is on the state to prove that either Kyle's life, the burden is on the state to prove that Kyle didn't think his life was in danger. When you've got somebody in a mob yelling, "Get his ass," and that's directed at you, and now there's people in that mob chasing you, I think it's going to be really difficult for the state to prove to the jury that Kyle did not think he was about to die. I think it's pretty obvious that Kyle was about to die had he not acted in self-defense. And I think it's very clear from the video, and I think it's going to be really difficult for the state to prove that he wasn't. And so if for some reason the verdict comes back not in Kyle's favor, you can be sure that it wasn't because the state made their case. It was because the jury were cowards. But that's 2.5 weeks from now. We don't know what's going to happen. I don't want to presume idiocy where they may well spectacularly impress us. Who knows? But my concern is that this stuff seems rather obvious to critical thinkers, to people who are informed about current events, people who critically analyze content that they're getting on a regular basis, as we do, being highly informed on current events and politics and philosophies and arguments and that sort of stuff. As I described yesterday, our legal system has a process for jury selection which intentionally filters out people who are critical thinkers. It intentionally filters out people who are aware of current events, and intentionally filters out people who have strong opinions about things that they've thought of. The people most likely to make it through the jury process and to judge you are people who don't have strong opinions about anything, people who don't critically think about information that they've gotten, as is evident by them not having strong opinions about anything, and people who just generally are uninformed about current events and the context and politics. They're just NPC blank slates. And it's possible that a jury case in which they are selected for, that verdict might be the first time they've ever been forced into thinking about something critically, into coming to a firm position one way or the other on. The ideal juror from a lawyer's perspective, from a judge's perspective, is somebody who's never made a firm stance on anything before, that has no bias. If you've never made a firm stance on something, if you don't have any biases, if you aren't aware of current events, if you don't form opinions about politics, you're not a critical thinker. You're just going through the motions, especially in the current environment. If you're just looking at all this stuff, all these current events, all this politics, all the current state of the country and international affairs, and you just, I don't have any opinions on that, you're not a critical thinker. And that's the person who's most likely to become a juror. So, like I said, I don't want to kind of prejudge the jury, but it's just my qualm with jurors in general that it's likely they won't pick up on this stuff. I am hopeful I will be wrong on that. Let's see here. We're almost done with this. The state continued to play other various videos, went through dozens today, of various events and times and locations, just again reestablishing all the basic facts of the case, reconstructing where everybody was at certain points of time during the night. The state prosecutor asked the detective if at any point Rosenbaum had a weapon. This was the last thing that was asked. Well, it was the last thing that was asked before I stopped watching. The state prosecutor asked the detective, did Rosenbaum have a weapon that night? The detective responds, no, which is ridiculous because we've seen Rosenbaum holding a chain. We saw him swinging a bag with unknown things inside of it. Also, it gets into the definition of what is a weapon. Is a blunt object a weapon? Because the state was also trying to imply that a skateboard is not a weapon. Well, it's contextual. If you're swinging something at somebody, it's a weapon. And so it kind of gets into the definition of like what is a weapon. Also, it kind of gets into the whole presumption that a weapon is required to present a threat. So what the state's trying to say is, well, Rosenbaum wasn't armed. He didn't have a weapon. Therefore, he did not represent a threat to which you needed to defend your life against. And so therefore, Kyle knew. What the state's trying to say is, well, Rosenbaum didn't have a weapon. Therefore, Kyle must have known Rosenbaum wasn't a threat. And so Kyle executed him, not with the privilege of self-defense. The fact that Rosenbaum did not have something that is a specific weapon is irrelevant. You don't need to have a weapon to represent a threat to somebody. Rosenbaum was a rapist, pedophile, and Kyle was a child. It does not matter if Rosenbaum had a gun or not, or a knife, or a rock, or a bag. It doesn't matter what Rosenbaum had. He was acting in a very clear, threatening manner to Kyle, chasing Kyle across the block, and Kyle defended himself against him. The state is trying to make the case that Kyle did not need to act in self-defense. Again, this goes back to what we just talked about. The video, you can see Kyle's retreating from the situation. You've got a mob that screams, "Get his ass," and then that's shortly before the second set of shootings starts happening, because after yelling, "Get his ass," the mob chased Kyle down. Let's see here. I think it's funny that the state wants to create this fantasy land where Kenosha wasn't dangerous, that Kyle should not have presumed his life to be in danger because, there wasn't any fires at the second car source except for that one little, whole car fire. And so, it wasn't really in danger. The state at multiple times had tried to set up scenarios and then asked, did you feel in danger? They did this with Dominic, and they'd asked the Corey Washington, and they were trying to keep reiterating like, the situation wasn't that dangerous that night. It really wasn't something that you needed to fear for your life for. And I think it's hilarious that the state is trying to make the case that the situation wasn't so dangerous that you needed to fear for your life, when the situation in Kenosha was so dangerous that the police decided to abandon the area, yet Kyle should feel safe. The state's position is that it was okay for the police to feel so endangered that they abandoned Kenosha to anarchy, yet even though it was too dangerous for the police, Kyle should have felt safe. This was literally the purge that happened in Kenosha, as we saw in several other cities throughout the summer, where the state just abandons the city to anarchy for the night, and they come in the next morning to grab the bodies, but they don't do anything to help the situation daring. That's how the purge movies worked. Is they just said no laws tonight. The next morning, civil services will come in and clean up the bodies, but there's no laws before that. And that's what's going on in all the major cities right now. And while Kenosha's not even a major city, it's just happened to be a nexus point for leftist violence. But where these situations had happened during the summer of 2020, the city had just devolved into chaos. It had become the purge. It was lawless for 6 hours at a time. And then the next morning, it's coming and cleaning up the bodies. And then we'll go ahead and prosecute Kyle Rittenhouse. But the state felt no obligation to defend anybody's life or to create a safe environment during the purge. No, they were just abandoning the citizens to anarchy. All right. So this is where they decided to take a break after the state was finished with their first round of questioning with Detective, what was his name again? I can't remember his name. Martin Howard. It's because it should be Howard Martin. Like, that sounds like a proper name. Like, Martin Howard just sounds backwards. What happened here? There we go. Okay, so the state prosecutors finished their first round of questioning with the detective. The next round was presumably going to be the defense attorneys cross-examining the detective. They took a break around 4 p.m. Eastern, at which point I decided to cut that off for the day, and I started streaming a little after 5 Eastern, so that was about where I'd stopped. So tomorrow I will again attempt to watch tonight's part of the court case, and then tomorrow's beginning part of the court case, and hopefully bring you another update. We'll see. Let's see here. I am going to try to find, you guys just hang out here for maybe a minute. I'm going to try and find this clip of the jury, or of the state prosecutor trying to argue that they can play this video, and the judge telling them that it's hearsay. I went through and described that a little bit ago. The exchange is something like 7 or 8 minutes. It was interesting. If you guys are done watching for the night, feel free to take off. If you want to come back and watch this later, go for it. But I'm just going to, once I find this clip, I'll let it play us out here. You guys let me know in chat too if you guys were interested in this. If you guys like this, if you guys wanted more, let me know. And I will give me a minute here to find this clip if I can. It's possible I won't be able to. Where is it? I can't find it. All right. Well, I tried my best. Should be in my history here.
Sites that are saying things that are totally bizarre. And I'm going to cite one only because
basis for it when they want to play statements of my client.
Ben Reverse stated you have to.
I almost found it here. Hold on a second.
Yeah, they're just trying to protect their property.
Oh, yeah, I know, but they...
Like, if that was my house and I didn't know what was going on, I'd be, you know... Yeah, they clicked. I know, but things are low from the...
Okay, so again, to kind of set up for this is that the state prosecution is playing a video that was ripped from one of the live streams that night. The filmer has a lot of commentary that they're putting over top of the video, and the state would like this commentary to be admitted as evidence. The prosecutor or the defense attorney says you can't do that because this isn't a witness and we can't cross-examine them. And here's the discussion that takes place after that. Again, thank you guys for joining us tonight. This will be the last I speak to you, and I'll just let this video play us out. Thank you for joining tonight, and I hope you're enjoying these updates here. I'm compressing about 10 hours worth of court case down into about 2 hours, which is probably a longer highlights reel than other channels are doing, but it's longer than what most of them are doing. So hopefully this kind of represents a middle ground of more analysis than what you're getting other places without having to watch the entire trial yourself. So hopefully this is providing some value to you. Hopefully you enjoy it. Let me play this video here, which was a fun back and forth with the state prosecutor and the defense attorney and the judge. Here we go.
Same as the earlier objection. If he wants to play my client, that's fine, but this is editorialing.
I understand the objection. The problem is there are portions of this that don't have anything to do with the defendant that describe the scene, and I'm trying to give the jury
That's
a sense of the
hearsay.
scene.
It's hearsay.
I'm not introducing anyone's statements for the truth of the matter asserted. I'm introducing it for the state of mind of the defendant as he watches
If
the
it's
scene.
not for the truth of the matter asserted, it's irrelevant.
No, it goes to state of mind, Your Honor.
State of mind of
Of the defendant. When he sees...
someone else's... would you do me a favor and step into the library for a minute?
Oh.
Please don't talk about the case while you're out of the room. Okay. First off, the Court of Appeals very strongly condemns sidebars, and we've used them for a number of purposes in this case, which I think everyone would agree have not touched anything which is an essential part of the case, and mainly have been management issues. But the Court of Appeals rightly wants to have a full record made, which cannot be made when we're having a little sidebar. So, and when you state your objections, then I've stated you have to state the objection here, or else I'll have to excuse the jury. And I think that was, we're going to get into this a little more deeply now. So I think we did the right thing to do that. And we'll try to keep it so that they're not inconvenienced too much just being in the library here. No, let me just set the stage here. I've talked about inaccurate things out on the media, and one of the things that I've read over and over and over again is about how I messed up the State against Jensen case, which is now pending downstairs. Actually, I had it 100% correct in the first place. I ruled that the disputed matter was testimonial evidence that had to be confronted, and your office appealed. This is 20 years ago, and it was fine. It was a big issue. It was a big case, and the state Supreme Court reversed and said, no, we're going to adopt a new rule that is to be applied in this case about waiver and forfeiture. And so it came back, and I said right in the record, this is going to get reversed again because it was an unsound ruling, unanimous. I hate to say that about the Supreme Court, but it's true. And of course, that has proved positive. So I tried the case according to the way the Supreme Court told me to try it, and that was 20 years ago. The man is still in prison, and the case has again been reversed because of the evidence that the Supreme Court told me to admit. I don't want to mess around with confrontation issues. I can't let you present evidence into this record, which is barred by the confrontation rule, and you're asking me to let this just run while this man is making descriptive materials to prove the state of mind of the accused. That doesn't make any sense to me at all.
First of all, Your Honor, nothing that's being said in this video can be construed as testimonial.
There was historical information that he was saying in the part that we did here.
It is not for testimonial purposes. He is not presenting it in anticipation of litigation. He's not giving it to law enforcement. It's not a report for the purposes of reporting a crime or for any pending legal action whatsoever.
Let's not even talk about it as confrontation. Let's talk about it as hearsay.
Then it goes to the defendant's state of mind, because the defendant is witnessing everything that's going on in this video. He is witnessing what's going on in the crowd. He's witnessing the response. He's witnessing all of these statements that are being made. And it goes to his state of mind. It's a present sense impression. And the defendant's state of mind, as we've all agreed multiple times in this case, is critical to the case.
Your Honor, start at the beginning for where I came in. The state argues that we've been doing this. One, Mr. Elijah, who was giving the editorial comments in the first video, he was here to be questioned. In this case, this individual who's in charge of the audio-video feed is not under the state subpoena. He could be. If they chose to do that, they could have him here and he could testify to his opinions and we could cross-examine those. That would be acceptable. What Mr. Binger is saying is, my client is there, so he knows all this. There's no proof that what that individual is seeing, filming, and commenting on, my client is looking at it, seeing, or part of it. That's why that person needs to be here to testify. I have no problem with this detective testifying as to people, places, and things from this video. We stipulated that. I did not stipulate to the editorial comments. I have no objection. Obviously, there's no basis for it. When they want to play statements of my client that are on video, that's not hearsay. But this and his statements regarding militia, things like that, that is hearsay.
So we've got two complaints here, or two objections. One is the confrontation clause. This is not testimonial. It doesn't even fall anywhere near testimonial. Therefore, confrontation clause, I don't believe, is a valid objection. When it comes to hearsay, Your Honor, we had a pretrial dispute regarding things that Joseph Rosenbaum did all night long that were not witnessed by the defendant. The defense argued that those things should come into evidence because they show the context, they show his character, they show propensity for violence, they set the scene here. And I argue to Your Honor that if the defendant didn't personally witness it, it shouldn't come in. That argument failed. You allow them to come in. We've heard in the opening statement a lot of things about Joseph Rosenbaum that I know personally, and the evidence I think will demonstrate that the defendant never witnessed that night. But they're going to come in to attack the character of a deceased individual. And I understand the Jackson ruling. I've read that decision. I understand all of that. The difference is, Your Honor, this is exactly what the defendant witnessed. He is right there. Now, counsel is asserting that the defendant isn't aware of what's going on at this scene. I don't know that. The defendant knows that. Well, he has the right to testify. I'm going to. Wait a
minute. You're right. He has the right to testify. He has no obligation to testify.
Absolutely not. But if he's going to get,
and if you're going to,
he is present. He's within a few feet of all this stuff going on. So it is a perfectly reasonable understanding that he is witnessing this and that this is forming his state of mind. He is seeing confrontations. We are showing the jury those confrontations. These are occurring right in front of his face. So this is him right there. I'm not showing stuff that was 10 blocks away. I'm showing what was right in front of him as he's witnessing. We've already seen him in this video. Now, if the defense wants to argue he didn't witness it, if they've got evidence to suggest that, they can argue that and the jury can make a decision. This is a factual dispute. The hearsay objection, again, these are not being, no statement that I'm showing this view is being offered to prove the fact of the statement. But hearsay does not necessarily have to be admitted for the truth of the matter asserted to be relevant. It can be admitted for other purposes, such as present sense impression, state of mind. These are excited utterances that are going on in the heat of a conflict in a scene like that. So there are plenty of hearsay objections.
There are so many things you're touching on that I want to be able to tackle them all.
Sure.
And this present sense impression thing, what the defendant was aware of with respect to what was pictured in the video, and I'll give you that even though the camera's aimed on him and is looking into his face and what he's seeing is actually the videographer, but I'll grant you he's there, but you're accomplishing the result as to what was available for his scrutiny when you show the movie, the video. I don't see where the commentary by the videographer is part of his sources of knowledge. That's number one. Secondly, getting back to the Jackson case and the ruling the other day, and I'm going to comment about the media again because there was a gentleman on TV night before last who said this is the most divisive case in the country today. So anything that undermines public confidence in what happens here is very important. It's important for this town. It's important for this country to have people have confidence in the result of this trial, whatever it is. And I don't care what it is. But people have to be confident. There are people on the media, on reputable sites, that are saying things that are totally bizarre. And I'm going to cite one only because it is exemplary, and it stems from the conversation we had the other day about the uncommunicated threat rule. You talk about things that occurred with respect to Mr. Rosenbaum that were unknown to the defendant at the time that the crime allegedly was committed. And you're right, under one subsection of that statute, the defendant has to have been aware of the incident in order to be an operative fact. But there's another one, the uncommunicated threat rule, which is an ancient rule of our law, which I talked about at the time of the ruling. And the Jackson case discussed it somewhat. It's also discussed here at Judge Weinstein's commentaries. And it's section 7.01, subsection 3, subsection C. And it says, if the defendant offers evidence of the alleged victim's character, it must be in the form of opinion or reputation testimony. And that was, I think, one of the things that you were advancing. It may not be in the form of evidence concerning other acts. When a defendant offers evidence of the alleged victim's character, then the process, well, I won't read that because it's not relevant. But then the next paragraph, and this is the critical one. When the defendant offers evidence of a homicide victim's violent character, but does not show that the defendant was aware of that character trait at the time of the incident resulting in the victim's death, The defendant is offering the evidence as circumstantial proof of the alleged victim's violent behavior at the time of the incident in question, and the offer falls squarely within Rule 404, subsection A, subsection 2, subsection B. On the other hand, if there is evidence that the defendant was aware of the alleged victim's violent nature at the time of the incident in question, evidence of the alleged victim's violent character is admissible in support of the accused's claim of self-defense, but solely under 404A2B. Under those circumstances, the evidence of the alleged victim's violent character is admissible independently of Rule 404A2B because it is relevant to the accused's apprehension of the imminent danger and the reasonableness of his or her defensive measures. So there's two different parts of the rule. One of them is the defendant has to have been aware of the decedent's violent acts or turbulent behavior. In the other one, it's circumstantial evidence of the victim's violent behavior at the time of the incident. That's what I admitted it on. Now, one of these, this was on CNN, Jeffrey Toobin and another attorney there, and the comment was made that the ruling was incomprehensible. And I think they obviously are not familiar with this rule. That's our law. That's the law in the Jackson case. It's the law in the case of the United States against Craig A. Smith, which is 230 Federal 2nd 300, 7th Circuit case from 2000. This is admissible evidence. But it applies under the statute to the decedent. It does not apply to the defendant. So you're mixing rules up here, and I don't understand any theory under which you can bring in what certainly seems to me to be hearsay when you could acquire the attendance of the witness.
Judge, there are two things. Do you have the modern site, an actual site for Wisconsin in terms of the rule? Because that 404 clearly is not a Wisconsin statute.
Well, I'll look it up. It's the same rule. It's 90404.
904?
It just changes one numeral, which has been the rule for as long as I've been practicing evidence.
What was the subsection? You said 404 subsection 2B2, was that it?
Yeah, it would be Wisconsin. The federal rules and the Wisconsin rules, as you know, have they basically are the same in most instances and in this one, but they just use a different numeral.
That's the greater latitude rule of child sex offenses.
No, it's not. It's not the greater latitude rule.
Well, under 90404 sub 2B2, that under Wisconsin statutes, that's the greater latitude rule for child sex offenses. So the greater latitude rule for child sex offenses, there may be a difference in the subsection lettering and numbering between the federal system, which is Rule 404, and Wisconsin statute, section 904.04. So I'm not sure where that section that you were mentioning, Judge, matches up with the Wisconsin statute. I think that is Mr. Krause's point.
All right. 90404, character evidence not admissible to prove conduct, exceptions, other crimes. And subsection, you know what it is? They changed not only the first digit, but they also changed the A's and B's to 1s and 2s. So you're right. I was reading from Judge Weinstein's commentary, but when you translate into Wisconsinese, it comes out as with numerals. But it's it's 90404 subsection 1 subsection B, and evidence of a pertinent trait of character of the victim of the crime offered by an accused And then under 90405, methods of proving character, is subsection 2 is specific instances of conduct of the in this case the decedent.
I understand, Your Honor.
So that's the basis upon which this ruling was made, and it's not incomprehensible, and it's in accordance with our law. And what is in the mind of the defendant is not governed by that rule. This is the character of the decedent.
I understand what you're saying, Your Honor. I want to briefly respond to that, if I may, and then I'd like to get back to this video. I think just generally, I have not watched Jeffrey Toobin or anyone else discussing this case on the media. It is of no concern to me, so I'm not in a position to respond to what any of those talking heads have said.
I don't expect you to. My point is
Sure.
that I want the case to be fairly tried, and I wanted people to understand that we want to go forward from this case, whatever the outcome is, and not have all kinds of people making inaccurate statements about what the law is.
I don't have any comments on the media's coverage, Your Honor, so I'll move on. This video contains statements from the videographer and other people at that scene. The confrontation clause issue, I don't believe is applicable.
Skip from confrontation to hearsay.
So let's go to hearsay. I am not introducing these statements for the truth of the matter asserted.
Then why are they relevant?
Because they go to the defendant's state of mind. They are
I'm
present.
going to invite you to respond.
Your Honor,
I'll hear you more, but I do want to hear his response.
Unless this unsubpoenaed individual can read minds, that is a ridiculous argument. This narrator is going to prove my client's state of mind? That's absurd. I don't know how to respond to that. And the general, and I don't even want to use this word, but panoply of what's going on here, if it's not the opinions of the narrator, that goes to what may or may not have been seen by my client. You know, somebody yelling, they're throwing things, or there's a laser. I'm not objecting to that, because that's part of what goes on and what went on that night. It was shown, even some at the gas station that Mr. Elijah was testifying to. What we're objecting to is the person who is running the feed and giving the editorial comments. That is hearsay.
Can I just ask, maybe we can short circuit this a little bit? What specifically is this person saying? Is it the word militia? That's I think, the triggering word here.
It seems to me you have the burden to tell me what that I should expect from this video that I never heard before, how I should be ready to pounce. Because you're offering a running commentary from a person who is not here under oath to give testimony, and you're expecting me to be ready at a moment's notice to figure out what's going to be the next word out of his mouth, and then try to put
my question was actually directed at the defense, Your Honor. I didn't mean to direct it to you.
All right.
So I think the difficulty practically, Your Honor, I understand the objection of the word militia, and I don't think it's hearsay. I think it falls within a number of exceptions, but nonetheless, if we're going to deal with that word, I guess there's a couple of options. One is I can try and go back, and I'm going to need some time to do this. I would need to go through this video and figure out every moment that word is used, and we will have to figure out a way to cover that up, stop the sound for that second that word is used. The other option is, and I think this is a perfectly reasonable one, is the judge, you can simply instruct the jury on this issue, that this is the narrator's statements. They are not to be, that the jury should give no weight to what the narrator is characterizing.
I've never done that before. In 50 years, well, in 38 years up here, I have never told a jury, I'm going to play this, and some of it might not be okay, but just don't pay any attention to that. that what you're telling me?
I respect the fact that you've never done it, Your Honor, but it has been done. It is a perfectly permissible procedure by the court. The jury is presumed to follow your instructions. We give them instructions on evidence all the time.
We're going to take a break right now. Would you ask the jurors to go upstairs and talk about the case, please? We're going to take a break. I think it would be prudent to do so at this point.
All right. Unless the narrator can read minds, then his argument is absurd. All right, guys. Thank you for joining us tonight. Appreciate you sticking with us. Hopefully you enjoyed this, and I will see you some point this week, maybe again tomorrow. We'll see. This is fun, though effortsome. I will see you guys later. Stay safe, and I will see you next time. Fox.